We have arrived at a unanimous verdict in the challenge to the electoral bond scheme. Therefore, you have the details.
No, I have the details there.
One minute, Mrs. Salve.
But my lord, I have to
direction to correlating to the purchaser and the political party.
My lord, para 76 does suggest that. Would your lordship just see it for a moment?
Don't go by what is suggested. Whatever you wanted to speak, just spoken in black and white.
Shall stand disposed of at this stage in the above terms.
And they had said in their own application that they have the bond numbers, etc. But they said that they were in two different silos.
That's right. Now we'll pass another order. We'll say,
would your lordships consider issuing notice to SBI? They may have something to say.
They should be here when the matter is going on.
No, I'm sorry, my lord. Please.
My lord, may I mention, my lord?
Mr. Aggarwala, just a moment. Duty bound.
I'm not appearing for SBI.
We have filed applications today morning.
If the application is not numbered, it is not registered, we'll follow what sauce for the goose is sauce for the gander. Mr. Rohatgi, sorry, no oral mentioning in my court.
No, I'm not. I'm in the matter. I'm saying.
My lord, the entire judgment has...
Second, you wait. Sorry, Mr. Rohatgi.
My lord, my submission is the entire judgment has been rendered behind the back of the public at last. This judgment doesn't constitute justificator. This judgment doesn't constitute justificator.
1 second.
Yes.
1 second.
This judgment is void.
Please listen. 1 second.
I am a citizen of this country.
1 second.
Yes.
Don't shout at me.
No, I am very soft.
Mr. Aggarwala, apart from being a senior counsel, you are the president of the SCBA.
Yeah.
You know the procedure. You have written a letter to me asking me to invoke my suo moto jurisdiction. That SBI has disclosed all details of the electoral bond which were in its possession and custody, and that no details have been withheld from disclosure. One 1501 for judgment. We have arrived at a unanimous verdict in the challenge to the electoral bond scheme and the amendments introduced to the provision of the Income Tax, the Representation of the People's Act, and the Companies Act, and the RBI. There are two opinions of this court, one authored by myself for Honorable Justice Gawai, Justice Pardiwala, and Justice Manoj Mishra, another authored by Honorable Justice Sanjiv Khanna. Both opinions of this court arrive at the same conclusion, though there is a slight variance in the reasoning which has been adopted. The information about the funding of political parties is essential for the effective exercise of the choice of voting. One of the factors which contributes to political inequality is the difference in the ability of persons to influence political decisions because of economic inequality. Economic inequality leads to differing levels of political engagement because of the deep association between money and politics. At a primary level, political contributions give a seat at the table to the contributor. That is, it enhances access to legislators. This access also translates into influence over policy making. The electoral bond scheme and the impugned provisions, to the extent that they infringe upon the right to information of the voter by anonymizing contributions through electoral bonds, are violative of Article 19(1)(a). We have applied the proportionality standard to determine if the infringement of the right to information is justified. The electoral bond scheme is not the only means for curbing black money in electoral financing. There are other alternatives which substantially fulfill the purpose and impact the right to information minimally when compared to the impact of electoral bonds on the right to information. On an overall balance of the impact of the alternative means on the right to information and its ability to fulfill the purpose, for contributions below 20,000 rupees, contributions through other means of electronic transfer is the least restrictive means. For contributions above 20,000 rupees, contributions through electoral trust is the least restrictive means. Thus, the infringement of the right to information is not proportionately justified for the purpose of curbing black money and electoral financing. Financial contributions to political parties are usually made for two reasons. First, they may constitute an expression of support to the political party, and second, the contribution may be based on a quid pro quo. The law as it currently stands permits contributions to political parties by both corporations and individuals. The huge political contributions made by corporations and companies should not be allowed to conceal the reason for financial contributions made by another section of the population, a student, a daily wage worker, an artist, or a teacher. When the law permits political contributions, and such contributions could be made as an expression of political support, which would indicate the political affiliation of a person, it is the duty of the Constitution to protect them. Similarly, the right to privacy of political affiliation does not extend to contributions which may be made to influence policies. It only extends to contributions made as a genuine form of political support. It is quite possible that contributions beyond the threshold of rupees 20,000 could also be a form of political support and not necessarily a quid pro quo arrangement, and contributions below the threshold could influence electoral outcomes. However, the restriction on the right to information and informational privacy of such contributions is minimal when compared to the provision of blanket non-disclosure. Thus, this lesser restrictive alternative realizes the right to information of an informed voter and informational privacy to political affiliation in a real and substantial manner. The Union of India has been unable to establish that the measure employed in Clause 7.4 of the Electoral Bond Scheme is the least restrictive means to balance the rights of informational privacy to political contributions and the right to information of political contributions. The Electoral Bond Scheme, the proviso to Section 29C(1) of the Representation of the People Act 1951, as amended by Section 137 of the Finance Act 2017, Section 182(3) of the Companies Act, as amended by Section 154 of the Finance Act 2017, and Section 13(a)(b), as amended by Section 11 of the Finance Act 2017, are violative of Article 19(1)(a) and unconstitutional. And B, the deletion of the proviso to Section 182(1) of the Companies Act, permitting unlimited corporate contributions to political parties, is arbitrary and violative of Article 14. We consequently issue the following directions. A, the issuing bank shall herewith stop the issuance of electoral bonds. B, State Bank of India shall submit details of the electoral bonds purchased since the interim order of this court dated 12 April 2019 till date to the Election Commission of India. The details shall include the date of purchase of each electoral bond, the name of the purchaser of the bond, and the denomination of the electoral bond purchased. C, State Bank of India shall submit the details of political parties which have received contributions through electoral bonds since the interim order of this court dated 12 April 2019 till date to the Election Commission of India. SBI must disclose details of each electoral bond encashed by political parties, which shall include the date of encashment and the denomination of the electoral bond. D, SBI shall submit the above information to the ECI within 3 weeks from the date of this judgment, that is by 6 March 2024. E, the ECI shall publish the information shared by the SBI on its official website within 1 week of the receipt of the information, that is by 13 March 2024. And F, electoral bonds which are within the validity period of 15 days, which have not been encashed by political parties yet, shall be returned by the political party to the purchaser, depending on who is in possession of the bond to the issuing bank. The issuing bank, upon the return of the valid bond, shall refund the amount to the purchaser's account.
I have respectfully agreed with the judgment ordered by Dr. Justice Prashant. I have also applied the proportionality standards, but with slightly different variation. My conclusions are the same. It's written in a way that the subject is complex and judicial review is always legalistic, but I've tried to simplify it.
If you see the directions which we have issued at page 76,
My lord.
we have not told you to do the matching exercise. We have asked you for a plain disclosure. Therefore, the ground on which you seek an extension of time to make the disclosure does not accord with the directions in the judgment at all. The judgment doesn't tell you to do that.
No, my lord, I'll tell my lord what we understand. If that is not so, then of course there's no problem. If your lordship is pleased to turn to para 221.
But then you simply comply with the judgment.
No detail.
Ultimately, even your FAQs, which were shown to us during the course of the hearing,
Yes.
the FAQs indicate that for every purchase, you have to have a separate KYC.
Yes, we have that. We have that.
Therefore, it's very clear that every time somebody made a purchase, a KYC was mandated. There is one set of documents, namely the electoral bond application form, KYC documents, citizenship documents, and pay-in slips.
My lord, there's no issue. We have the details. Please don't misunderstand me.
Therefore, you have the details.
No, I have the details there.
One minute, Mrs. Salve. Now, paragraph 10, you specifically say that all the purchasers' details have been kept in a sealed cover.
Yes.
In the main branch of the applicant bank.
Correct, my lord.
Just have to simply open up the sealed cover and collate the names and give the details.
My lord,
as far as paragraph 11 is concerned, you're saying that the donees' details are being kept in a sealed cover, envelope in a sealed cover. Open up the sealed cover and give the details. In fact,
tell my lord where the only bit of information.
If I'm not mistaken, the EC was asked to file an affidavit, which you in a sealed affidavit or details in a sealed envelope, which we have not opened. With regard to the donor details and other details.
But my lord, I have to keep
direction to correlate it with the purchaser and the political party.
My lord, para 76 does suggest that. Would your lordship just see it for a moment? If you
don't go by what is suggested. Whatever you wanted to speak, we have spoken in black and white.
No, in that, my lord, your lordships, please see that sentence. I'm not, my lord, we have no desire at all to try and expand our own job, my lord. Please see page 76. This by itself is creating difficulties. Straight away.
Mr. Salve, our judgment is dated 15th of February 2024.
Yes, ma'am.
We are now on the 11th of March.
Yes.
In the last 26 days, what extent of matching has been done by you? What steps have you taken in the last 26 days? The application is absolutely silent on that.
We can put a detailed affidavit on that, no, because I know
it should have been disclosed in the affidavit.
I agree, man. I agree.
State Bank of India, which is coming to us, we expect that there should be a degree of candor on the part of the State Bank of India. That this is what the work which we have done. The work is at this stage. We need an extension of time to carry out the balance of the exercise which remains.
But we have sought to explain the problem and the work is going on. I have another big concern, my lord. I cannot make a mistake in this. I'll get sued by the donor. I'll get sued by people because I cannot by mistake say A got it when B had it.
Highest court of this country. So where is the question of you being sued?
I'm sorry, my lord.
Whatever you are doing under the directions of the highest court of
No, my lord. If I make a mistake, if I say Mr. X got it instead of Mr. Y got it in a hurry to give the numbers.
As we take it, Mr. Salve, you are accepting that there's no difficulty in giving names of the donors who purchased the bonds and the amount they purchased the bonds. You have got no difficulty in giving details of the political parties who have purchased the particular bonds. The only difficulty is matching the purchased bond with that. But 26 days, you must have carried out at least some, say, 10,000 bonds you have been able to collate, 5,000 bonds you have been able to collate.
Quite frankly, what I saw, they were struggling with it. They were making charts which we saw were not matching. I'll tell you what has happened. No, I'll tell you candidly what has happened.
If I'm not mistaken, it was pointed out to us that the bonds had some number which under some instrument they were able to.
Yes. But that number.
That's all has to be done.
So that is no problem.
In pursuance of the interim order,
yes.
Election Commission of India has filed, details before us.
Or whatever they have.
In separate silos, if we can use that expression.
Yes.
The ministry has placed that, in secured custody with us. We'll direct them to open it here right now because since we were deciding a point of constitutional validity, we didn't consider it necessary either during the course of the hearing or thereafter. So we can ask them to open it and we'll ask the Election Commission of India to divulge whatever there is and we'll ask SBI to then divulge what we have asked them to do. You, Mr. Salve, you comply with the order of the court.
To give it to the ACI.
whatever ECI has placed in the court,
already.
we will direct that to be opened. We'll ask our court to make a copy of it, a digitized copy for the safekeeping of the court. And then we will return it back to the rest. We'll return it back to ECI for them to upload it on their website.
But what ECI has already, there's no problem. We will give to the ECI as in the time, if you're not to give us 3 months, we'll go and give it to the ECI. And they, as and when they get it, they can upload it. We want to make sure we get every bond number right, every donor right. Because this otherwise is going to create havoc. For today, for donors will come and say, this is not my bond, I did not purchase this, you put the wrong number on my bond, I did not give to so-and-so.
There's no question of that. Once he's given the KYC, he's given the details, you also have the application. The application will be having the amount.
No, I'm sorry, Marat. I'm sorry. My concern is he purchased bond number X. I by mistake, I put his number as purchasing bond number Y. Now, X may have gone to political party A, Y may have gone to political party B.
Why will that happen, Mr. Salve?
Because I'll tell Marat why. Because they haven't kept the
number one bank in the country. We expect them to be able to handle this.
Assistant General Manager files an affidavit in support of the application to the Supreme Court for modification and order of a constitution bench. It's a very serious matter when you ask for modification of an order.
I accept that one. I accept that.
An
I
assistant
accept that.
General
And we
Manager
have,
files an affidavit and tells us that, look, I'm finding it difficult. The information is maintained in 2 silos.
no, Marat, he has filed the affidavit because he's the man in the spot. He's the person who has to do this job. He's the level at which these accounts are kept. He said you must have the person who knows what he's talking about. So, Marat, give us a little time, we'll do it. Ask for time.
Clause 7(4) of the Electoral Bond Scheme stipulates that the information furnished by the buyer of an electoral bond shall be treated as confidential by the authorized bank and shall be disclosed only when called upon to do so by a competent court or upon the registration of an offense by a law enforcement agency. Full stop. Thus, in terms of the provisions of the electoral bond scheme itself, SBI is mandated to disclose information when demanded by a court. Full stop. What remains to be seen, what has to be analyzed is whether SBI is justified in seeking an extension of time. The crux of the submission of the SBI is that the matching of information to ascertain who contributed to which political party is a time-consuming process, since the information is maintained in 2 separate silos. Full stop. Now, the operative directions which have been issued by this court, as reproduced earlier, the operative directions of this court directed the SBI to disclose the transactions as set out in Direction B and Direction C extracted above. Let's stop. SBI submits in its application itself that the donor details and redemption details are available, albeit in separate silos. Full stop. In other words, the directions which have been issued by this court require SBI to disclose information which is already available to it. Next para. Full stop. Irrespective of whether the unique identification number, which is not discernible to the naked eye, will enable the disclosure of details, the submissions of SBI in the application sufficiently indicate that the information which has been directed to be disclosed by the court is readily available. Next. In view of the above discussion, the miscellaneous application filed by SBI seeking an extension of time for the disclosure of details of the purchase and redemption of electoral bonds until 30 June 2024 is dismissed. Full stop. SBI is directed to disclose the details by the close of business hours, 12 March 2024, and publish the details in its official website no later than by 7 days. By 15 March, by 5 p.m. on 15 March 2024. We place SBI on notice that this court may be inclined to proceed against it for willful disobedience of the judgment if SBI does not comply with the directions of this court as set out in its judgment dated 15 February 2024 by the timelines indicated in this order. Full stop. The miscellaneous application for extension of time shall accordingly stand dismissed. Contempt petitions shall stand disposed of at this stage in the above terms. Now, just one thing, who's appearing for the State Bank of India? Because in our judgment, we had directed disclosure specifically of all details of the bonds, including the purchaser, the amount, and the date of purchase. They have not disclosed the bond numbers because that had to be disclosed by the State Bank of India. Because if you see our judgment.
Chip's judgment is quite clear on that. All details.
So all details have to be furnished by the State Bank of India.
I am for the government.
And they had said in their own application that they have the bond numbers, etc. But they said that they were in two different silos.
That's right.
The SBI's application for extension was on the ground.
SBI is not a party. They were here because they moved an application.
Anyway, if they disclose the bond number, we have no problem with it.
Lordships may issue notice to SBI, my lords.
Yes.
Now we'll pass another order. We'll say,
would your lordships consider issuing notice to SBI? They may have something to say.
why do we have to? They should be here when the matter is going on. If they're not
I'm
here,
sorry,
why-
my lord. Please. They filed an application which is disposed of. They are not parties.
But really speaking, we can take exception to what they have disclosed because they were bound, duty bound.
I'm not appearing for SBI.
The way
The court can pass an order.
Lordships may hear. I'm not here, my lord, for political.
someone-
Correct.
And your lordship had said that the reason
B and C of your lordship's original. I'm not appearing. I'm assisting. I feel, my lord, SBI needs to be.
the order of this court, the judgment of the Constitution bench required SBI to furnish to the ECI all details of the electoral bonds purchased and as the case may be purchased or as the case may be redeemed by political parties, including The date of purchase, what are the other,
Yes.
Date of
Your
purchase,
lordship's
Name of
PNC
purchase.
for my satisfaction.
name of purchaser, purchase which have received, sorry.
And the
And the
denomination.
denomination, date of purchase, name of
the name of the
purchaser and
purchaser.
denomination.
and the date of purchase stroke redemption. Full stop. It has been pointed out, it has been submitted that that SBI has not disclosed the electoral bond
Number.
the electoral bond number. What is it called? Is it called the unique identification number, or is it called
It's called the alphanumeric, unique alphanumeric number
the
on each bond.
the alphanumeric number of the electoral bonds? Full stop. The Solicitor General submits that since he is not appearing for the SBI, a notice may be issued to SBI. Full stop. We direct the registry to issue notice to SBI, returnable on Monday.
Fair
We
enough.
keep it on Monday. Very good.
Keep your plans.
My lord, may I mention, my lord?
Mr. Aggarwala, just a moment. Don't interfere.
Ji.
A copy of this order shall be forwarded by the Registrar Judiciary on the Standing Counsel appearing for SBI.
May I request, my lord, one thing?
Mr. Kapoor.
Sanjay Kapoor.
Lord, may I request, your lordships are keeping this on Monday. We are guests among us. This mentioning can wait, my lord, till Monday. I hope, my lord, I can convey myself.
There we agree with us. There is something to be said for what the solicitor said.
Lord,
Mr. Aggarwala, would you like to mention this on
Yeah,
Monday?
my lord, I sent yesterday one request to honorable lordship
Credit us
for
with
suo moto.
Credit us with reading our files and correspondence both. Would you like to mention this on Monday, Mr. Aggarwala?
Whatever,
I would request
that
him to
lordship
mention
is
on
fully
Monday.
aware.
All of us will request him. to
Yes,
mention
madam.
on Monday.
We join.
Your lordship may permit
We are
me to
at
file
item on this,
proper
Lord.
application, but I was not a party, my lord.
Please respect the sentiments of your colleagues.
All of us are jointly requesting you to mention on Monday.
Keep your guys.
Grateful.
Obliged.
Just one second.
At this proceeding, but I am appearing on behalf of the major Milord Industry Association, which is the ASSOCHAM, UK Milord, and CI. But we have filed applications today morning. Lord,
If the application is not numbered, it is not registered, we'll follow what sauce for the goose is sauce for the gander. Mr. Rohatgi, sorry, no oral mentioning in my court.
I'm not, Milord, I'm in the matter I'm saying. I am saying,
We have no
Milord,
such application on board. Let it be circulated. We'll deal with it in the normal course.
but Milord, I am respectfully submitting. If
Sorry,
you make
appearing
an order
for big
today,
clients, we will not tolerate this. You have to follow the rules in my
but
court.
Milord, if your lordship make an order today, my application will be infructuous. I am saying kindly defer the issue of grant of alpha
Mr.
numerical.
Rohatgi, you are aware of what proceedings were going on. You could have intervened at that stage. What is this after the judgment is passed? You want to intervene now?
Milord, the order is of 15th March. Ask
No, but
Milord,
you are aware about the proceedings pending before this
But
court.
Milord, we were not
Arguments are going
parties
on
anywhere.
together.
we were not parties at any time.
Everybody, the whole world knew that this matter was being heard.
Milord, I have
Come
no.
back 1 second, Mr. Rohatgi. You come here after the judgment is delivered. You are now, you file an application. That's not the way.
Milord, I have come only in regard to
Circulate and-
15th March. Kindly appreciate.
No, Mr.
I have no problem in
Rohatgi,
declaration
hear you.
of the list of donors
Rohatgi.
or the list of recipients.
Mr. Rohatgi will not hear you right now. We have a specific
Not
application which is on board. You ask your advocate on record to follow the procedure. File an email. It will be dealt with by my registrar listing. We'll take a, we'll
But
get
Milord,
no.
I am saying
No,
kindly, Milord,
If I do it for Mr. Rohatgi, senior
No, no,
counsel, then Mr. Rohatgi, you look at me. As Chief Justice, I have no face to tell all the other juniors to whom I declined list mentioning in the morning. What sauce for the goose is sauce for the
I am
gander.
not mentioning, I am Milord appearing in the matter and making a submission.
We have no such application on board before us.
Milord, I have brought it with me.
I've made myself.
My lord, the entire,
I have emailed
entire judgment has,
Second, you wait. Sorry, Mr. Rohatgi. Yes.
no, my lord, my submission is the entire judgment has been rendered behind the back of the public at large. This judgment doesn't constitute This judgment doesn't want to constitute resident data.
1 second.
Yes.
1 second.
This
1
judgment is
second.
void.
Please listen to me. You are
It is-
not, 1 second.
I am a citizen of this country.
1 second.
Yes.
Don't shout at me.
No, I am very soft.
Please listen to me.
Yes.
This is not a Hyde Park corner meeting, okay? You are in the court.
Yes.
You want to move an application?
No, my lord.
File an application. What I told Mr. Rohatgi applies to you.
No, my lord, the question is, my lord,
There's no question you've got.
my friend has come.
Mr. Nedumpara, 1 second.
Yes.
You've got my decision as Chief Justice. We are not hearing you. If you want to file an application, move it on the email. That's the rule in this court. No
my lord,
further.
we will go by what your lordship.
All, please.
Whatever your lordship says, we will go by that.
Do you want another contempt notice?
No, my lord, your lordship will go by
You have
whatever
had
your
enough
lordship
of it in
says.
Bombay.
Only I have said what I wanted to say. That this judgment is rendered behind the back of the people of this country. It doesn't bind us. It doesn't
Please.
constitute us. It is not a
Please
representative
do not,
process at all.
please, once we have said no, please move the
I
application
accept
by email.
what your lordship says.
Do not continue and persist.
Yes, I only said it was not a representative proceeding.
Nedumpara, you are
All the way coming from Kerala.
You are obstructing in the administration of justice.
Hello, my lord.
You are obstructing in the process of administration of justice.
The entire judgment is against behind the back of these people. Parliament has been rendered
Hey,
irrelevant.
That's all. That's all. We heard that. Please, that's all. You made it.
We are in a democracy.
We will not hear you till you follow the procedure prescribed.
My lord, we are filing it.
Please do.
We are filing it.
Please do. We'll consider it afterwards.
Yesterday
That's
at
it.
10 o'clock.
I-
My friend came from Kerala to took a 1 o'clock flight.
Have not-
Be kind to us.
last-
Be kind to
That's
us.
all, please. We will not hear that.
In democracy.
Please call for the
the-
application.
the
Please
good
follow
of,
the application.
democracy is-
Mr. Aggarwala, apart from being a senior counsel, you're the president of the SCBA.
Yeah.
You should know the procedure. You have written a letter to me asking me to invoke my suo moto jurisdiction.
Yes, my lord.
For locus to mention
So
anything.
that I should not
You
disturb
have to
lordship.
restrict what you
We
have
should
said.
not waste it honorable time, court's time.
Fair
That's
enough.
why.
Lord,
But
only that.
These are all publicity-oriented stunts. We will not permit it.
Handmaid of
Whatever
Please,
lordship feel better.
Mr. Aggarwala, please keep it at that. I may have to say something more, which will be perhaps a little distasteful.
My lord,
Please,
we are all
please close it.
members of the bar who are senior to your lordship.
Nedumpara, it is enough now.
Also senior to your
It
lordship.
is enough.
64-year-old man, Lord.
Be kind to us, later. We are very polite and begging with your lordship. The lordship has a soft language.
Nedumpara, we have been telling you that you are interfering, you are obstructing us.
No.
Now, if you don't stop, we will have to.
When we are not heard and we feel threatened. Sorry, Lord.
But I appear for the State Bank.
Yes. Mr. Salve, in
Yes.
our order which we, in the judgment which we delivered, we had expressly asked State Bank of India to disclose all details. The language of the judgment was all details have to be disclosed. Therefore, that includes the bond numbers as well. So,
But I,
let SBI not be selective in the disclosure of details. We intend
But I-
to clarify that it shall disclose all details, including the bond numbers, and every part of the information which is in its possession and custody. Don't wait for an order of the court. We banked on the fact that the State Bank of India would be candid and fair to the court.
my lord, whatever your lordship say, if your lordship say bond numbers, we can disclose the bond number. There's no problem.
Tell us
Somebody
one-
can
why-
screen them. And
Why has the SBI not disclosed?
I wanted to, my lord, tell my lord how we understood your lordship's judgment. Give me 5 minutes only to explain our conduct. We'll, of course, if your lordship say give anything more, everything will be given. But there's no question.
SBI's attitude appears to be, you tell us to disclose a particular detail and we'll disclose it. That's not fair process.
My lord, how we understood.
The
may I-
SBI requires, this is the judgment of the Supreme Court. As chairman of the State Bank of India, I'm duty bound to comply with the judgment. I will disclose every part of the information which is in my custody as directed by the Supreme Court. Because when we said all details of the purchases, that means every conceivable detail which is available with State Bank of India. And we clarified by saying including. That should be, State Bank of India has the best legal advice open to it.
May I, my lord, take your lordship? So, my lord, your lordships felt this what would ensure transparency, that you give all this, but you keep it in a sealed cover. So, my lord, a political party doesn't need bond number. If a political party comes and says, I have received so much from so and so, that gives
But
the requisite
Salve, we
details.
take it you're not arguing a case for a political party, right?
No. On the contrary,
You're for the state.
I'm saying the reverse. I'm so sorry. I'm saying the reverse. According to us, the data.
Mr. Salve, I have a few questions. First,
Yes.
tell us in what format is the data on the purchase and redemption of electoral bonds stored by the SBI?
So, Malad, as I had explained in the application which we filed, because at that time we were functioning under the edict of anonymity, which had not been stayed. So, at that time we were directed to preserve anonymity, including we had to take measures that within the bank.
What is the format in which you maintain the data on purchase and redemption of electoral bonds? In what format do you store
In two
it?
silos. Your Lordship noticed that in the next order. So the data is maintained in two
You store
silos.
it in 3 silos. From your application, it emerges now that you do it in 3 silos. The first silo is the bond number. The
Bond number is only on the bond.
purchase, and the third is the redemption.
My lord, bond number is only on the bond, and it cannot be read except through under a UV light. That was only done, my lord, like authentication, because it was a bearer bond. That's what was sought to be.
What's the purpose of the alpha? And second question, what is the purpose of the alphanumeric?
The alphanumeric is the bond number which is visible only under a UV light.
Is it only a security feature, or is
it a security feature entirely?
In the audit trail, do you also?
No, my lord, audit trail is separate. That's why we do the entire KYC. In the KYC, we have a bond unique number. It's not the bond number. You have a marker number of a client.
Third question:
yes.
How does the redeeming branch?
Yes.
How does the redeeming branch?
Yes.
Match the electoral bond number to determine that it is not a forged bond?
So they were not. That's what I'm saying. When they received it, the person encashing it gets it. He sees that it's a valid bond because you see the security feature. You don't keep a record of it. The physical inspection.
While redeeming it, the only way you can ensure that it is not a forged bond is to match the alphanumeric. Without
there's nothing to match. It's like seeing a currency note. It's like seeing a currency note. You know that's
the alphanumeric.
Yeah.
But cashed in the last 15 days because it's only valid for 15 days. So therefore, they will have to also match. When was this bond?
I think Mr. Bhushan should hold his peace for a minute.
Fourth, what is the information that you see when you scan the alphanumeric?
Malad, you see a number.
The details of the purchaser and the bank which issued the bond when you scan the bond?
No, Malad. That's what I'm saying. That correlation was not kept. For the reason, it's like this. Mr. A or Mr. B come and buy the bond. So they go to branch A. They do the entire KYC information is done, their bank account details, etc., everything is done. That is silo 1, if one may so call it, which is nothing near Rohatgi. That's been fully disclosed. That bond finds its way into the hands of some political party. We don't know who gives it, how it goes, how many hands it changes. It finds its way in it. We next get to see the bond when somebody comes and says,
Mr. Salve, assuming that you construed our order based on the interim order merged with the final judgment of our court.
Malad, even in the final judgment,
say that we will interpret our final directions in the light of the interim order, which has merged with the final judgment.
Malad, your lordships,
all details.
That's why we came to my lord.
Mr. Salve, we'll clarify to put it beyond any.
No problem. No problem at all.
We'll say that now SBI will not only disclose the bond numbers, but it shall also file an affidavit again before our court saying that you have not suppressed you will not withhold any details in regard to this within the purview of clause B and C of para 221.
Correct. I don't think there's anything else which remains.
But you have to disclose all details. Let there be because the burden should not lie upon the court or the petitioners to say, but this one has not been disclosed. But now this has not been disclosed.
Now we'll disclose it, Malad, whatever.
We must have finality to it.
Yes, we'll do it, Malad. There's no problem.
Mr. Salve, the idea behind the interim order was, in case the writ petition is allowed, then data should come out. And that's what exactly is required. Nothing more.
I must say so, Malad, as out of whatever, as Malad, the Chief Justice is saying, your Lordship will clarify. We will give every bit of information, relevant, not relevant. We'll give every bit of information which we have. So that, Malad, there should be no feeling that SBI is interested in somehow holding something back. I only want, Malad, to share one thing. Malad, your Lordship's judgment is one of the leading judgments on the subject on transparency, voters' rights, and balancing democracy, balancing the competing virtues of and trying to minimize the role of money while recognizing the role of money in elections, etc. It goes over a lot of subjects. The one thing the Lordship's judgment was not meant for, possibly, and not designed for, is to give birth once again to a now dormant PIL industry, which will go after each industrialist and say, investigate this, investigate this, investigate this, investigate that. And the idea is the voter should know, which is absolutely, and may not say, give the bond number, we'll give the bond numbers. The voter knowing is one thing, but this as fodder for the next 10 years to have PILs saying investigate so and so, investigate so and so. That is, I don't think, the purpose of your Lordship's judgment. That was not what it was meant for. And your Lordship will see whatever safeguards need to be put in place.
Now, my lord, I have something to share. And I have been watching this very painfully, my lord, outside the court. My lord, your lordships sit in kind of a silos. Your lordships are, my lord, in an ivory tower, not, my lord, in a negative sense of the term. But what we know here, my lord, your lordships never come to know. The way in which your lordship's judgment is playing out, my lord, something your lordships must, my lord, be informed as highest court of the country. But what has happened is, my lord, our case was that we want to curb the black money. A criminal may have paid the donation, but ultimately the donation comes in the white economy and we could not persuade your lordships. Lord, your lordships passed a judgment. Lord, every one of us understood the judgment and the directions in a particular way, that what your lordship wants is not, my lord, kind of a witch hunting. Earlier, my lord, our case was that witch hunting would be by the political parties. If A party is given, B party in some other state might victimize the donor. Now, my lord, the witch hunting has started, my lord, at some other level, my lord, not at the governmental level. The application comes of the SPI before your lordships on 11th of this month, my lord, and your lordships also, my lord. That's how, my lord, we understood, clarified the position. But most serious things, my lord, start happening thereafter. Lord, those before the court started giving press interviews, deliberately embarrassing the courts, my lord, and there is, Lord, a non-level playing field. My lord, on this side, nobody can rebut that. Neither government can do, nor state bank can do, nobody else can do. Thereafter, my lord, a series, a barrage of social media posts, my lord, at least intended to cause embarrassment, started during these days, 2 days. And thereafter, my lord, now it's anybody's field. It's an open field. My lord, statistics, your lordships are aware, can be twisted in any manner the person wants. It's a matter of, my lord, intelligence of the reader to understand. Now, my lord, based upon the twisted and other statistics, my lord, any kind of posts are being made. I know, my lord, your lordships cannot control that. The question is, would your lordships, my lord, consider issuing a direction which has a necessary and inevitable fallout, which the court would not be able to control? Lord, that saying Mr. Rohatgi gave this money to this, then they have their own conclusion.
Mr. Solicitor, we are only concerned about enforcing the directions which we issued in clauses B and C of para 221.
That's
as judges, we decide according to the Constitution.
Correct, my lord.
We are governed by the rule of law. We are also the subject matter of comment in the social media and the press. But surely, as an institution, our shoulders are broad enough.
No, I'm saying, I'm not for a second.
Our court has an institutional role to play in a polity which is governed by the Constitution and the rule of law. That's the only job.
Lord, my purpose is to inform your lordships that there is something else playing out which neither your lordships intended nor the scheme intended. And, my lord, kindly bear that fact in mind. On 11th of March, my lord, we thought that we are ad idem, that this information would help the voter to take a call whether to vote in favor of a particular party or not. My lord, thereafter, this started in a very systemic.
Already. Order.
Can I assist you?
No, Mr. Rohatgi, we don't need assistance right now at the conclusion.
I am the person who's going to.
Lord, they have no stakes in the matter.
Forget my application.
No, Mr. Rohatgi, we'll not hear you when your application. We have to follow procedure in the court. It's a constitutional court.
Allow us.
Mr. Rohatgi, no, Mr. Rohatgi. I told you the reason for it. We are now at a stage when the
I
judgment
am not on my application, not that it has become influential. I am now only saying
No,
that-
Mr. Rohatgi, we don't need any assistance at all. We are clear. We had very able assistance on both sides. We don't need any third party assistance.
I meant not.
Your lordship didn't get a
One
proper
second,
assistance.
Very recently, I was asked about a critique on a judgment. I need not mention which judgment. And I said that, look, it's no part of the role of a judge, least of all of a constitutional court or even a civil judge, to defend their views. Once we declare a judgment, it becomes public property. It's the property of the nation. If there is the property of the nation. In our interim order, we said that the disclosure shall be made with effect from the date of the interim order, 12th of April 2019. Right or wrong, we have taken a conscious decision that the cutoff will be the date of our interim order. And we also explained why we took that date. We said after that date, of course, the Constitutional Bench has an option to go all the way back from the date of the bond or from the date of the judgment, some place via media, some via media in between. We took 12th of April 2019 because it was our considered view of all of us five that once that interim order was pronounced, everybody was on notice, what we told Mr. Rohatgi. Now we have maintained that if you want that to go back to 2018, that's in the nature of a review of the judgment.
So the only reason why I'm saying that.
Modify that date.
No, the only reason, because your lordship asked the political parties to give donor details to the election commission prior to that interim order. And while some of the political parties have given donor details, other political parties have not given donor details. The major political parties have not given donor details. And one political party, which is in power in one of the states, says, if somebody came and left it under our door, 10 crores of electoral bonds was left under our door, we don't know who it was. So therefore, I am saying that because this is leading to a situation, though your lordship asked the political parties to disclose donor details by that interim order, only some political
Mr.
parties.
Bhushan, we have understood that argument, but what we are directing was the numbers are given, it will sort out a lot of problems. A lot of your issues will
But for that period of 2018 till
Oh, that will
April
we are not sitting in a
2019,
review.
We have taken a conscious.
we are faced with a situation where the
Mr. Bhushan, this will really be a substantive modification of the judgment. We can't do it like this in a miscellaneous application.
no.
And
In the light of the disclosure which has come to light of the political parties, that's why I'm saying.
it was not a
If the
classical
political
decision,
parties
it was
had
conscious.
disclosed the donor details, this would not be required.
Draw the line somewhere, we had to hold the balance. We now, there's no manner of doubt that SBI is required to make a complete disclosure of all details in its possession. Full stop. This, we clarify, will include this we clarify would comprehend the alphanumeric number of and the serial number, if any, of the bonds which were purchased and redeemed. Full stop.
You were voting number 1.
The application, this was on your application, I think you had moved this, no? The application was by the Oh yeah, we had it. Mr. Harish and Salve, Learned Senior Counsel, states that there is no reservation on the part of SBI in disclosing all details which are in its possession and custody. Full stop. In order to fully effectuate the order and to obviate any controversy in the future, we direct that the Chairman and Managing Director of SBI shall file an affidavit on or before 5 p.m. on Wednesday, date daldo.
Could we have one more day, Thursday?
Stating, yes, that's certainly 5 p.m. on Thursday, indicating that SBI has disclosed all details of the electoral bonds which were in its possession and custody, and that no details have been withheld from disclosure.